It's me. What's up? There she is. Ooh. Toot toot. Yee. All right. So, good morning, party people. So, I've been thinking about some stuff. And yesterday I went back through I think I mentioned my process. I go back through, I reread things, I relook at things, I set things aside, I go back and look at them with fresh eyes. Just normal kind of stuff when you're doing, when I'm doing the kind of reporting that I do, to turn up stuff and junk. So yesterday, we went through Richard Allen's first interview with the police. And that got me thinking about it got me thinking. So today I thought I want to talk about the hearing that I keep going on about from May, because I think it's some of the pretrial hearings I don't believe get enough attention because I think they set a really good stage for what the hell's going on here and why everyone is so concerned about how the arrest and trial went down. So I do want to get to that, but as you see on the scroll, I put Robert Ives in there. Does anybody remember Robert Ives? Because I've been thinking about him a lot lately, and thinking about, and if you don't know who Robert Ives is, Robert Ives was the county prosecutor when the girls were murdered. Yep. Well, first of all right, let me say hello. Let me say hello to everybody. Yo. Hey, yeah. What up? Hope your day's better today, woman. Morning. Hey, yo. The royal we. Toot toots, that's right. She's here. She's queer. Get used to it. Good morning. Hey, yo. Oh. Morning. Okay. So, got that nonsense out of the way. It's not nonsense. So the first thing I want to talk about is technicalities. And I think that this is important. There were a lot of comments on the interview I did with Andrew Baldwin the other day. Most of it was really, really great. I mean, people were very receptive. Think what you want about Baldwin, but I think more information, no matter if we agree with it or disagree with it or want to tear our own faces off after listening to it, is good. More information is always good. But I did get, I didn't get as many, but I did get a few people that were like, screw Richard Allen, blah, blah, blah. But I think this one I noticed, and I don't usually read all the comments because actually there were a ton, and I'm not good at follow-up. But this one stuck out to me because I think that, let me bring it up. Because I think that I want to talk about this for a moment. And I took the person's name off because who cares? Because I think a lot of people feel this way. Hear me out. So this was a comment on Baldwin's interview. It says a travesty would be getting Ricky off on a technicality. They wouldn't have had him from the get-go with a follow-up interview, and that's why he never stepped forward again. Okay. Now, The biggest thing I want to talk about, all of this stuff right here, I don't really necessarily care about. What I care about is this first line. The travesty would be getting Ricky off on a technicality. They would have had him at the get-go with a follow-up interview, and that's why he never stepped forward again, right? Okay. So, great. This gentleman, lady is entitled to their own opinion. You know, but I think the point that I want to make is that when this person talks about those technicalities, that would be a shame if Richard Allen got off on a technicality. I think that when people talk about that, the correct answer is the technicalities you're talking about are constitutional rights. The constitutional rights that the elected prosecutor for the county has the mandate, the responsibility to ensure are protected. And so, because there are people out there that think like this, and that's totally cool. Everybody can have their own ideas about guilt or innocence. I really am not. My point is that technicality, right? That is actually, you mean the right to counsel? Which technicality? Which technicality are people talking about? And so, to me, that is my response to something like this. It would be a shame if he got off on a technicality. Well, that would be on the state then, wouldn't it? Let's just play that scenario all the way out. Oh my gosh. Good morning. I'm just doing a chat and chew. Oh, hey, Jamie. Who else came in? Hello. Woo! I combed it. Thank you. So anyway, when people bring up like the getting off on a technicality, the pushback and and it's not even a pushback, it's just correcting them. It's like, sir, ma'am, those are constitutional rights. So if you consider your constitutional rights a technicality, then yeah, you bet. So I think we need to disabuse people of the idea that somehow defending a client, demanding that the state do its job, and its job is to protect the rights of the accused, as well as try a case based on the evidence, not get a win, but get justice. And God knows Nick McClellan is, talk about hair looking good, right? You know, that there's the case that's going, I think a good analog here for some people is the thing that's going on with the Walsh case. Now, not the crime part, right? I mean, the guy's looking pretty bad on paper, but the part that you know, the part that I think people can see is that there were some shitty cops. Sorry, 1 minute. I got like 1 moment, please. Sorry. What people see that happened again with the Michael Proctors of the world and the whole kit and caboodle, they see in that Walsh case that this guy looks, oh, I mean, talk about Google searches, right? How formaldehyde, how do you do this? Blah, blah, blah. So that's really easy to see. And the defense in that case came at the state and said, we're going to move to exclude this, and this, because the cops didn't go about things in the right way, because it's Michael Proctor and it's boss, or it's you know, Norfolk County or whatever. And so the question becomes, who deserves a fair trial? Does that guy deserve a fair trial in Massachusetts? The one that talks about, you know, hacksaws and just basically writes a manifesto. Yeah, he does. I hate to say it, but he does. I don't even hate to say it. He does. He's presumed innocent. I think he's guilty as hell. But the point is that if the cops screw up, that's not on the defense. Make sure that when people push back on this and say, oh, a technicality, no. You get a problem with that technicality, go take it up at the next election of your county prosecutor. I don't know, run it up the flagpole. So that's my morning screed about that comment, the technicality. I say good day, sir. So anyway, it's just, ugh. So the next thing I wanted to kind of talk about is going back again to the beginning. I came across some audio of Robert Ives, who again was a former prosecutor before in this interview. There's a couple of them. There's one that was on television, and we can watch a little bit of that. But there's also one that was just an audio, and I actually do think it was on Gray Hughes's channel, but I don't quote me on that. But I pulled some audio from the interwebs, and I think it's really telling because going back, I don't know anything about him really necessarily. But what I do know is he seemed to comport himself like an adult, like a serious public servant. And, you know, that's what they are. So, do you guys want to take a look at that? Or do you want to discuss the hearing that I've been talking about? Or do you want to talk about, I mean, this is a good question. I think actually, let me see if I can find it, because this is, I don't know if let's see what this one does. It all sounds good to me. Yeah. Wait, I saw Amy was in here. Aren't you supposed to be on vacation? Get on vacation. All right, let's see. All right. Okay. There he is. This is from 2021. So I just pulled this up, so I haven't listened to it. So let's take a listen as to what we can learn. And that's kind of the way that I look at these things, is I listen for things like I did yesterday. I listen for things that stick out to me. Sometimes I hear new things. So whatever. Here we go. Let me know if you can hear it.
I knew the girls were missing the day before. And I can tell you, I at least, and I think most people thought, oh, well.
I knew the girls were missing the day before. I mean, everybody did, right? Okay.
You know, they're hanging out with friends. They've had a fight with mom. No such thing happened. Don't misunderstand me. But we didn't think much about it. And when the next day, when their bodies were found, it was shocking to everybody. It was certainly shocking to me because in Carroll County, such a crime was unprecedented. You know, people kill each other sometimes.
Okay, but wait a minute. I'm sorry. I have to stop, though. Wasn't Flora before this? And does that not count? Okay. Sorry.
Generally, it's a crime of passion. It's about boyfriends, girlfriends, husband, wives, or some just emotional dispute. we've never had, in my time, I was first prosecutor in 1987. We never had a murder, a robbery, or a random murder. You know, we had drunk driving deaths. We had murders of husbands and wives, but nothing like this. And so it was tremendously shocking. And the outpouring of law enforcement support was incredible then, because not only did the FBI come in extreme numbers, but the law enforcement, the police departments of the surrounding counties, the sheriff's departments, the city police departments, they all sent detectives. And in those early days, there were plenty of leads, you know.
I just want to put a note here, and if anybody's taking notes, playing along, I want to know, do we have a list of all of the officers from those agencies?
But there was no great lead. You know, people have asked me sometimes, was there a point where y'all knew who did it, but you couldn't prove it? No. When I was involved, that point was never reached. There was never a time where we thought, this is the person, we just don't have enough to charge. But there was so much physical evidence at the crime, and the crime had been found so immediately after it had been committed, that it's the sort of thing that experienced law enforcement officers, experienced investigators all believe, oh, this is going to be solved really quickly. And normally it would be. It's shocking to me that it hasn't been solved today. In today's world, we have cell phone evidence and we have DNA evidence. But if you had been a police officer in 1960 and you had arrived at this crime scene with the traditional physical evidence that was there, and then not to mention the fact, of course, we had video and audio of the person I think certainly killed the girls.
Why though? Whoops, sorry.
People ask me sometimes, well, this is going to be solved really quickly. And normally it would be. It's shocking to me that it hasn't been solved today. In today's world, we have cell phone evidence and we have DNA evidence. But
okay, DNA evidence. So again, I'm writing this down. DNA evidence. Sure did. You sure did. Sure did.
If you had been a police officer in 1960 and you had arrived at this crime scene with the traditional physical evidence that was there, and then not to mention the fact, of course, we had video and audio of the person I think certainly killed the girls, you would be certain.
Why though? Why are you certain? Why do you think certainly?
To catch them within 48 hours. So when you add in the fact that we have evidence today, or we have investigatory methods that we didn't have in the 60s, all police officers, I believe anybody who was involved, I doubt anybody in that first 24 hours had any doubt it was going to be solved within 2-3 days.
Mm-hmm.
And
go on.
Just from the evidence at the scene.
Yes.
Okay.
The circumstances of the crime. Yes. Mm-hmm. And, you know, then after that, what happened was they developed a system where when there were tips or there were hints or there were reason to believe somebody was in the...
Okay. This is the part. Okay, here's another thing we got to listen to. Because again, this is from 2021, before the arrest of Mr. Allen. All eyes, I know you're here, so just file it in that giant brain of yours. But he's going to explain to us something. I think this is the audio about their elaborate, pretty much fail-safe tip system.
They would assign, we had so many officers working on it that the guys they give them sheets, in effect, go find these people and interview them about where they were that day and so on. And so there was this unbelievable manpower, totally unprecedented in my experience, working on this and enthusiastically and passionately. And I would have been certain, if you had asked me at the time, I said, oh, next couple of days, they're going to find a suspect and actions to be taken.
Maybe you did.
Not because I had any particular feeling about a particular thing. It's just because of the circumstances of the crime.
At the scene.
Yes. I told people before, there were times in those early days, it'd be late at night and guys wouldn't go home because they thought, no, we're going to go out and do this. And then we're going to solve this because that's the perception everybody had. Not because we had necessarily a really good lead, just because it just seemed like, well, of course this is going to be solved. The location is it's not a tourist attraction or anything. You know, if you weren't from around here, you'd have no reason to even know such a place existed.
Sir, I said it again and I said it again. Now, I have not been there. But man, growing up in and around these kinds of places, I knew places counties away that I don't.
You know, the trail actually terminates at the bridge.
No.
The girls had gone out because it was a beautiful day, 52 degrees, as I recall, in February. They just decided we're going to go out for a walk. And I remember at the time, I would see on the internet nationally people saying, I can't believe those girls were out there, as it was the wilderness. You could walk from my office downtown out to where they were in 20 minutes,
right,
maybe half an hour tops. And you could drive there in 2 minutes, 3 minutes. And so it was just on the edge of town. In fact, there were houses. In fact, where the crime scene is, there's a house up on a hill that can actually look down.
Right.
The backyard can look down and see that house, or the crime scene, I should say.
Yeah.
And so the idea that they were someplace dangerous, I wouldn't have hesitated to have my child at that age to be walking out there. That's another thing that's shocking about the whole thing. Well, I guess I fear at this point that the most likely thing is, and this is a terrible thing to hope for, is that some other crime would be solved and the person, as has sometimes happened in the past, the person would say, oh, I committed this crime at Delphi also. I started to say, on the one hand, because it's not a very famous kind of place, I always tend to think it was a local person. But the fact that it's not been solved, and the fact there doesn't appear to be any motivation for it, it appears to be a serial killer type of thing. I'm not saying it is, I don't know, but makes me wonder if it wasn't a random act by somebody who isn't around here all the time. But I don't know. I mean, I'd like to tell you I have a strong feeling about that, but I don't. Early on, I would have said, well, it's surely somebody local, because who would know to be out there? Why would you be out there? Why would you even expect to find any other human beings out there in February?
So
it's broad daylight. This is something that needs to be emphasized. This is not like these girls were in a back alley in the middle of the night.
Okay, so what I'm gathering, just again, I got to make some notes here because I'm with him. I'm with you. Because surely, don't call me Shirley. Surely, you would have thought you would have caught the person by now. Surely, expanding the idea of what could have happened and who could have been involved, say, to a wider area, that determining maybe they're not local, that would have been a great thing to do. To expand that search, expand the criteria, to think laterally, to investigate things that happened in broad daylight, right? Allegedly. We don't know when it happened. We don't know when it happened. So, yeah, I mean, so I want to know what he thinks about how miraculously this got solved, quote unquote. And just putting a note here too is that he was subpoenaed by the defense, and that subpoena was quashed because Nick McLean said nope. And I was talking to Osbrook. I don't know where the hell he is, but I was talking to, hey yo. I was talking to Osbrook earlier about this, and the thing with having a former prosecutor give testimony on the stand, certainly there's things that are work product or whatever the case may be that he wouldn't be able to testify to, but we know by his own statements, and I'm going to play another little bit of an interview. He was at the crime scene. He was out of the crime scene. I don't know. He's not real clear about his interaction out there, but bring him as a fact witness. Why not? And again, what? You're not in chat prison, bitch. You are so high maintenance. But yeah, and Gull did shut that down. She did. Why not bring him on to say, just to say what the situation was, to put another perspective on what was happening that day from a person that was there and was the elected, county attorney at the time. What's the harm, right? I mean, and this is not wrong either. I mean, okay. Side tangent. It wouldn't be my chat if it wasn't a side tangent. Does anybody remember the guy? Shit, what's his name now? He's from Iowa, was a trucker, was arrested maybe 4 or 5 years ago, having been found through familial DNA to have murdered women basically from coast to coast, from Colorado and Tennessee. They got his DNA from a cup from a I don't know, he left it in his shopping trolley thing. And he was on the loose for years. And so, and I know a lot of comparisons have been made to the Evansdale, Iowa girls. I mean, I don't know. But thinking laterally about these things, and there was none of that from what I can tell within the ISP. There just wasn't. They weren't interested. I don't know if it's lazy, how much of it was lazy, incompetent. And then when that lazy incompetence starts a rolling, then people try to CYA, and then things just get out of control. I don't know. But you're not wrong. Anyway.
Broad daylight.
Let me play that a little bit again.
The human beings that be out there. Why would you be out there? Why would you even expect to find any other human beings out there?
Because it was a nice day.
It's broad daylight. This is something that needs to be emphasized. This is not like these girls were in a back alley in the middle of the night. They're broad daylight.
Right. So that is that. Let's take that down for a hot second. Thoughts, comments, questions?
I want to buy your house. I can pay you cash.
Look, and this is right. Man, let me tell you something. Growing up in the Midwest, if it was February and the needle hit 40, it was tube tops and shorts, baby. It just was. We all know this from the Middle West. It's like, yay. So I would expect everybody to be out there. And that's the other thing I could never, anyway, whatever. But yeah. Sure. I didn't get that from what he said, but yeah, I mean, I don't have any, I didn't get that from that interview, but, he didn't say anything about the family. Let's see. But there is some audio, and I do think and I'm not pissing on this guy. I think actually, like I said, he seemed to be one of the people that really had some integrity. Let me see if I can find this. Boop. Right. Tunnel vision. All right. So let me pull this up. This is just some audio that, and again, I got to take another. I was trying to find it. I loaded it into I downloaded it from the web, the interweb, and I put it into my Auger. That's like the transcription software. And now I can't find where it originally came from. And I'm beginning to think it came from a Gray Hughes channel, but it wasn't an interview by him. So if I figure it out, when I figure it out, I will link to it because I don't want to use somebody else's content. But this is without, I don't want to use anybody else's content without proper attribution. But again, I'm not sure because I can't find the bookmark that I thought I put. So this is from, let's see. Let me see if I can put this up so folks can follow along. Oh, yeah. No, so sorry. Yeah, absolutely. I mean, and it's like when I was a kid, like I said, it seems so ordinary, you know, to be out there. There's nothing weird about it. And I think the one thing that I did take away from that too, and I'm glad, thank you for pointing that out and sort of bringing me back to the beginning of his comments. I think that in the beginning, everybody was like, yeah, everybody was out that day, maybe not out there, but it was a beautiful day. But then, and I could be wrong, but my perception is that as the years ticked on, it became a much more, just hear me out, a much more nefarious scenario. Now, the brutal murder of two 13-year-olds is always going to be nefarious. What I'm talking about is a narrative. It took on something more in you know, when Doug Carter is spouting things about the Lord and making references, you know, biblical sort of references, that's by design. I mean, that's a narrative setting. So anyway, so thank you for bringing that back up. I heard about this. I don't know how one scrubs the internet, though. I really don't. And I'm not. Oh, Andy. Hello. Andy with an IE. Hello. Whoa. Happy to see you next Tuesday. Okay. And I'm not going to be, just listen, as a programming note, I'm not going to be around next week or the week after that. So you won't be hearing from me. I'm leaving. Now I heard it too. But let's see. He does mention a few things in this audio. So this is my own personal, and I don't know if you can see it or not, but it's a transcripts from the audio I pulled down.
He did. I was the prosecuting attorney in Carroll County, and I do trust him. So what can I do for you, Mike?
So hang on a second. I don't know if you're going to be able to hear this or not. Let me see. Actually, let me try one other thing. This might not be the best way to listen to it. One moment. Here we go. Let's try this. Remove, add. What the hell kind of file is this? I don't think it's going to let me do this. One moment. Talk amongst yourselves. Son of a bitch. So everything's off to a rip-roaring start.
He did. I was the prosecuting attorney in Carroll County, and I do trust him. So what can I do for you, Mike?
Did anybody hear that? That is so low.
My name is Rob Ives. I was the prosecuting attorney in Carroll County at the time that Abby and Libby were murdered. And in addition to that, I was the prosecuting attorney for a prolonged period of time afterwards, during the period of time, particularly when the FBI was in Carroll County in great force. Well, most recently for 7 years, but overall, I was the prosecuting attorney in Carroll County about 18 years.
Okay, hang on. Let's do this.
Well, when there's a really major felony in a small county,
Please stand
Carroll
by.
County is 20,000 people, 380 square miles, a highly agricultural county. There aren't very many people there. And when there's a major crime, a murder, rape, even most burglaries, though I don't always know.
I'm going to put this up again. I'm sorry, because I think that it's so hard to hear. I'm going to put it up so you all can follow along. Look, man, this is a dynamic set of circumstances.
My name is Rob Ives. I was the prosecuting attorney in Carroll County at the time that Abby and Libby were murdered. And in addition to that, I was the prosecuting attorney for a prolonged period of time afterwards, during the period of time, particularly when the FBI was in Carroll County in great force. Well, most recently for 7 years, but overall, I was the prosecuting attorney in Carroll County about 18 years. Well, when there's a really major felony in a small county, Carroll County is 20,000 people, 380 square miles, a highly agricultural county. There aren't very many people there. And when there's a major crime, a murder, rape, even most burglaries, though I don't always know as a prosecutor there's been a burglary that's occurred. When a really major crime's occurred, they're going to contact us. And while I am not involved in the crime scene, forensic work, and so on, I was out on the day the bodies were discovered.
Okay, so he was out there on the day, and that right? I mean, wouldn't you? Wouldn't you be out there? So, I mean, but that was one of my things about calling him as a fact witness. What did you see? He can testify to what he saw, right? So can you guys still hear it or no? Because I'd be interested to hear what you guys think.
No, it's typical. You know, I don't know in really big counties or urban areas, probably not. But for me and for my deputy, Mr. Bean and we're both longtime prosecutors. When we're talking about a major crime scene, a murder, the main reason we want to go is not to tell the police how to do their job, but so that when people are explaining the crime scene to us, that we have a context in which to put that explanation. So if there's a murder scene at a house or outdoors or any place like that, I was always going to want to go. Well, to a limited extent, in a major case, sometimes prosecutors may make suggestions to the police. We may have our own ideas about some follow-up that might be done, but generally we don't run those investigations. But certainly in Carroll County and with the Indiana State Police and the Carroll County Sheriff's Department, we all get along really well and we work together really well, and they're interested in my opinions. But more importantly, as cases go on, subpoenas need to be issued and search warrants need to be issued. And
Hang on. Is that where this comes from, DB? This is not, he wasn't talking to Gray Hughes. I know that it was somebody named Mike. Does anybody know who that is? I have to find where I got this from. Said something about Mike. Also, it's kind of inconsequential, to be completely honest, where it came from. I'm going to link to it when I find it, but I'm not going to get into a discussion about other creators.
so I need to be familiar with the facts because I produced all that. When I was the prosecuting attorney, I produced all that material. And thus, the more I know about the case, the easier it is for me to understand what it is they want to do and why they can do it. And sometimes, as a prosecutor, you have to say, no, we just don't have enough to get that. We need to get more. Or alternatively, the police sometimes convince us, no, we got this and this and this. And sometimes, we become convinced they're correct.
Okay, this is interesting, right? So when I was a prosecuting attorney, I produced all that material. And thus, the more I know about the case, the easier it is for me to understand what do they want, and want to do and why they can do it. Sometimes, as a prosecutor, I say no, we just don't have enough to get what we need to. And alternatively, their police sometimes commences and we've got this and that, and I become convinced that they're correct. So I would be interested, if he would have prosecuted, if he would have signed off on the search warrant that came out after that interview that we watched yesterday. I don't know. Maybe, maybe not. But that was a shit show.
Materials, search warrants, or subpoenas, or similar things without having a proper foundation.
Ooh, proper foundation. Yeah, I don't know. Dumb question, but why did he step down? Yeah, I don't know. I mean, why did Diener jump out the back window of the courthouse and drive away after he signed that batshit bloodlust thing, right? So, yeah. I mean, the thing that he's saying all the right stuff. We don't want to be going to a judge asking for investigative materials, search warrants, or subpoenas or similar things without having a proper foundation for that. So, I mean, for those of you, how many of you were here yesterday to watch that initial interview of Mr. Allen? When I talked about my armchair Judge Judy lawyering, that to me, they didn't have enough for a search warrant. Now, I don't know, man. I don't know. Did not feel right. Especially since there were so many misrepresentations in that search warrant application. It was just horseshit.
Well, it's really difficult, as I told Mr. Hughes on
Mr. Hughes.
The difficulty is, first of all, I'm afraid I'm not going to remember details correctly. And secondarily, I want to be very careful that I'm not releasing information that the investigators haven't decided to release. There are good reasons why information is not released. Sometimes the police want to know things that suspects don't know. And in addition, they want to know things that if a person tries to make a confession for publicity purposes, as you know, no doubt, sometimes people confess to things they didn't do. You want to make sure that...
Whoa, wait, what?
Young people
hang on.
If a person tries to make a confession for publicity purposes, as you know, no doubt, sometimes people confess to things.
People sometimes confess to things they didn't do. Now, did they do that before the trial? Because, I mean, there were a lot of people that confessed to this crime, no? And that was before they were thrown in solitary for years. And I honestly cannot. Could be. Don't know. Thank you, DB, even though you're a turd sometimes. So, the more from 2017, he did an interview for 2017, All Eyes. I don't know. I got to find it. But it's just, or 2018, maybe it's not. I don't know what the hell I'm talking about. The thing is that yesterday I got so cheesed off, and you know me, I get cheesed off, and then I get cheesed off. But I can't help but think with that crappy search warrant application that was just, and again, it was a cut and paste nightmare that was predicated on what they wanted to hear. It had nothing to do with the reality of they cherry picked from what Mr. Allen said. They cherry picked. And I would say they just straight lied about the car, at least. He was pretty unequivocal until they forced him into a corner at the very end. So, you know, can you imagine if on the 22nd, when was he arrested? Sorry, my God, how can I forget when he was arrested? The 26th, when he was arrested. Can you imagine if the lawyer they had hired took a look at the search warrant affidavit and said, I need to see that video from that interview that is cited in this affidavit signed by Tony Liggett and Nick McClellan? Do you, as the lay jury of this chat, honestly believe that we would be here? Because whether or not they would have gotten the search warrant thrown out, I mean, the evidence was, it was not evidence, right? But man, it's just like, why wasn't that done? That, yeah, yeah. Anyway, I'm going to let this run for a little bit. Talk amongst yourselves. I got to go feed the cat. So, but just if there's things that you hear, please drop it in the chat, because I do want to know if you're picking up things that maybe you hadn't heard before or thought about before, because I know I did.
They didn't do. You want to make sure that you know things about the crime scene that are not readily available to the public. And thus, I have to be really careful. I can tell you, I have to recall when the girls were reported missing, because it's not unusual for teenagers to be missing for a period of, hours or a day, because they've run off, they've run off to Canada. I actually had 2 young people run off to Canada one time. And generally you think, oh, well, they'll turn up tomorrow, they'll turn up the day after. And the next day it was shocking when the girls were found dead. And so, the crime scene is at the end of a walking trail. And one thing that has been reported very well is the bridge that's shown in the pictures is not actually on the walking trail. The bridge is not safe to cross, but people cross it all the time. In fact, one factoid, which you may already know, is that a lot has been made sometimes of the fact that the suspect is looking down as he walks. Well, he's looking down as he walks because anybody walking across the bridge has to look down, because that bridge has not been in railroad operation since, I believe, 1987. And so it's not in very good shape, and you have to watch your step to cross it. Well, there's no law on the subject. And one thing that's hard, I've had to explain to people in the past, in Indiana, in some states, I understand in New York, the prosecuting attorney is actually at the top of the chain of command of all his local police departments. But in Indiana, the prosecutor is not in the chain of command. The prosecutor can ask the police to do things, he can tell them to do things, he can embarrass them if necessary, but he really can't order them to do anything because he's not in the chain of command. Now, in reality, the police are extremely cooperative, and they don't want to cross prosecutors, they don't want to be in a doghouse with prosecutors. But on something like this, it's more a question of what makes good sense. Prosecutors are not investigators. There's nothing legally that prevent me from releasing anything, but I'm not a professional investigator. The detectives in the state police and the leadership in the state police make judgments about what they think should and should not be released, and I was never going to second guess those judgments. Now, I guess don't misunderstand me. I thought they were doing something horribly wrong. I might have released something else, but I didn't have that feeling, and I wasn't going to second guess their decisions about such matters. I think if anybody looked at all the various evidence, any 2 people would have slightly different opinions about what should and should not be released, but I'm not interested in second guessing them on that. The one thing that don't think was emphasized enough, even though it was certainly released, was the fact that the image of the suspect is an image from a video from a cell phone camera at great distance. People kept asking, well, why don't they enhance that picture? Why don't they make that picture? Well, there's no pixels to enhance. There just aren't very many pixels there. And so they did a marvelous job, really, of getting that picture up to the quality it is. And I know that's confused people out in the public. Well, I don't, because there's no magic, as you know. I mean, you have X number of pixels. Those pixels are a certain color. It may be that you can enhance the image by adding to the contrast, reducing the contrast, but you can't do anything to change the fact you have X number of pixels making up the picture.
I'm back.
And as such, you only have certain resolution.
So yeah, this is an old interview of Ives, the scootily poop from the time, but I'm just going to play just a wee bit more of it where he does talk about the crime scene.
There is a lot of crime scene evidence. Some of it is somewhat odd, but when I say that, any murder scene tends to have odd facts about it. I mean, in real life, obviously, people don't kill people really all that often. And this crime scene, there's a lot of evidence. There's a lot of unique facts there. And
what? Okay. Okay, hang on a second. Let's just listen to this again, shall we? Because
there is a lot of crime scene evidence. Some of it is somewhat odd, but when I say that, any murder scene tends to have odd facts about it. I mean, in real life, obviously, people don't kill people really all that often. And this crime scene, there's a lot of evidence. There's a lot of unique facts there. And honestly, I'm shocked, and I promise you, police are shocked that it wasn't solved in a day or two, because it just didn't seem, we're not used to in rural Indiana. Normally, if person A murders person B, it's obvious who the suspects are. And usually it's pretty obvious how to prove they committed the crime. This crime is very strange. But let me put this, go ahead. No, go ahead. No, I mean, the crime scene was physically strange, but that's for the state police to decide what to release and not release. I've said that before. It's very odd.
I've said that before. It's very odd, right? So, you know, I swear to God, I've seen the non-secular thing. I know you guys are talking about it, but I swear I've seen it. Boop, boop, boop. Let's see. Well, he said Mike. All eyes. Atta girl. So that was, I mean, there's another part that I would like to have an answer to, because he was, okay.
You know, obviously police make decisions to arrest people all the time. And if someone confessed or there was some piece of physical evidence, DNA evidence or such, that linked the person closely to a crime, well, they're going to go ahead and make an arrest. On a case like this, if you
What now? But see, this is the thing, right? They had DNA. In a case like this,
it's kind of hard to answer that, because in a case like this, they probably weren't going to make an arrest without talking to me.
now I want to put a point here, and Osbrook, if you're still in the chat, this is for you, because the DAs in New York, where I live, they are the top of the chain of command in a homicide investigation or whatever. They don't just make the charging decisions. They are sort of where the buck stops. For all the, I mean, obviously not the FBI, but for any New York district law enforcement. And so what I've said is that in Indiana, that's not the case. In Indiana, it is actually, you know, the prosecutor only comes in sort of at the end, he made it sound like, to make a charging decision. I don't know, man. That doesn't seem right. Does it? Anyone? Anyone? I know, right? Oh no, your credit card's expired. I know. Okay, I could tell you shit about her for days. I can't. Okay. So Michael says maybe where the political buck stops, but prosecutors don't control law enforcement. It's interesting. I mean, I guess it varies state by state, right? Yeah, that's how I do it in Norfolk. Right. Cops want a warrant. Well, he gets a swirly. Correct. What? What did I just say? Oh, God. Oh, God. I don't even know what I just said. So, yeah. Let's see. I wanted to see if there was something else. Okay, hang on. Let's see what he has to say about Mr. McClellan.
What people think is relevant has often surprised me. And so you shouldn't assume that, oh, well, A plus B equals C. They might want to know a few more things. And so it's a problem sometimes because when you're a prosecutor, you try a lot of cases and you see the things that go wrong. Some police officers go their whole career and never have to testify at a jury trial. And so sometimes, not detectives, actually detectives, they'll not understand, why are you being so picky about this? Well, being so picky about this because you never know what that last fact is important. You never know what that last convincing fact would be that will make a juror vote guilty. Because you're asking a lot of people to vote guilty in a criminal case. I'm not going to, I don't want to speculate about that because that's not my decision. That would be Mr. McClellan's decision. I don't want to put him in a position where, well, Rob Ives said he do X. You could look at the Indiana law and you could see the penalties are extremely harsh for a multiple murder, and probably what you would imagine. And I don't know what the tactical decision making would be by whoever is responsible for this case to determine what charges they file. Yeah, I will say this. I thought initially it had to be somebody local, as people have said. And now I really don't know. I guess I'm afraid it might be somebody who happened to be there at the right time. There was no logical reason anybody would have known those girls were going to be there that day.
Wait, but didn't they know about... Oh, okay. All right, now I've got to find this. So well, that's they absolutely wield so much power. You know that, right? I mean, compared to the way Nick McClellan comported himself in this trial, right? He basically was a yes man for law enforcement. And when I compare it, well, I mean, there is no comparison to New York City. So I guess I'd have to think about somewhere outside of, but whatever. I'm not going to argue with you. You know, I don't. So, okay. Yeah, that's what I thought. I don't, you know, right. Exactly. That's why I kind of backed off that. So has Ives spoken since the trial? I don't think that he would, or he did, but I mean, that's a great question. Well, he's effective. I'm talking about the, yeah, I mean, compared to, I mean, I'm sure that he and Gull ran lines the night before. You know this, DB. You know this. I'm kidding, but it kind of feels that way. Yeah. So, I mean, this goes on for a while, but I just thought it was interesting to pull that up and just kind of listen to the thoughts on that. But let me take this. What TV channel broadcasts a non-secular interview? Yeah, I don't know. I mean, I think that, you know, we could consult the Wayback Machine is sometimes your friend. But I don't know. I think it's enough for me that it was odd, right? I just, I don't know. It just going back to listen to it. Crime Lights used to have, okay, it's gone, girl. All right. Well, okay. So we're going to move on because I've had it up to here. And I do actually want to talk about the transcript I'm obsessed with. Also, I've been reviewing Dr. Kaur's testimony. I have thoughts, but I'm going to save that for a minute and go back to Her Royal Highness's All Eyes transcript hub. Where is it? Christ, I feel like I had this whole thing memorized. Hold on a second. May. March. Here it is. This one. Whew, Lord. Okay. So this one, this is the, and again, I'm going back to the pre-trial. Let me throw it up here. So going back to the pre-trial stuff, because I know everybody's reading all the transcripts, and you know, Teresa has done some great stuff, and I know a lot of people listen to that. I know Nick Starro was doing some reading of some of the pre-trial stuff. This one stuck out to me, and it's hard to take them in isolation, I understand, but this one stuck out to me as a really shining example of the way that Gull and Nick interacted. We'll talk about this some other day. Don't get me. Anyway, so I just want to read through this, and it's quite long, so I'm going to just buckle up. These are, so to put in context, this was the May 7th, 2024. Back then, they were getting ready to go to trial, I think at the end of May. Is that right? Somewhere around in there. And this is when they were doing a motions hearing, and they blow through a ton of information in this. And so I'm just going to read everybody's part, and we're just going to see if we can't get through it, see what your takeaways are. Okay. Proceedings. Here we go. The court. We are here in the state of Indiana versus Richard Allen, blah, blah, blah. Show the defendant is here in person with Mr. Baldwin, Mr. Rozzi, and I'm sorry, I don't know the lady at your table. Jesus. Attorney Bradley Rozzi says, this is Miss Auger, Jennifer Auger. Court. Okay, she's the attorney that entered her limited appearance for digital forensic information. Rozzi. She did, Judge, and there was an appearance that was entered a week or so ago that was general appearance. Court. I've entered an order on that, and she should be receiving it shortly. It was a confidential order. Mr. Rozzi. Would the court, I'm sorry, may I? The court. No, the state's hereby their chief elected prosecutor, Mr. McClellan, Mr. Luttrell, and Ms. Diener. Yes, what? Mr. Rozzi. Well, to the extent that it might have an impact on what she can do at the hearing today, I was suggesting maybe we could approach the bench and you could advise on the nature of the order, just so that we are not crossing some boundaries that the court is not permitting us to do. Court, you may approach. Sidebar. So that sidebar, the court. I was not aware of the limit. I granted your motion as an expert for an expert. She's the expert apparently in digital forensics. Not the limited appearance was for this very limited issue. And then I see a general appearance. I don't know what that is. And I asked for an explanation. I don't have the order. It's not in the file. Mr. Rozzi. Okay. Court, because it's confidential order. So no, I'm not gonna. Mr. Rozzi. Well, she's not an expert. She's an attorney. Court. Well, she's listed as an expert in the field of digital forensic in Mr. Rozzi or in Mr. Baldwin's request. Attorney Jennifer Auger. Question. Inaudible funds. Lots of inaudibles when you go through this stuff, by the way, guys. Court. Yeah, for funds. Miss Auger. Oh yeah, the court. And I approve that. No, I approve that. I know she's an attorney and Rozzi. Yeah. The court. So she entered a limited appearance for that specific purpose. And then all of a sudden I see general appearance. I don't know what that is. I haven't authorized a general appearance. I authorized a limited appearance. Mr. Rozzi. I understand that. I was the court so that Mr. Rozzi articulating to the court that what the posture was to make sure we were on the same page. The court, I believe we are. And I don't know what her role is going to be. I'm assuming it's limited to the digital issues that you have raised in the past. Mr. Rozzi, yeah, I think that was the original intent. And then obviously because of the workload and the late discovery, which we're continuing to receive, which has just been the natural course of things, we felt like that we didn't want to be penned in when we got into court with her just being able to talk about a limited issue. So basically just, asked the court to recognize her as one of the attorneys in case that she can. The court, well, that's something that assist us in litigating at this late hour. The court, well, then that's something we'll have to discuss because I haven't approved that. Mr. Rozzi, sure, that's fine. The court, I've approved a limited appearance. Mr. Rozzi, I just want to make sure she's not doing something today that you haven't or you are prohibiting her to do. That's why I asked. The court, as long as she's limited to the digital issues, then I don't have a problem with that. And that's what I've approved. Mr. Rozzi, yeah, I think that's what the confusion is. And again, this is all sidebar. Jesus wept. I think that's where the confusion is. Where are the parameters in that sphere? Because those terms of art, and we've learned that in the past couple of weeks, as you know, we've done some discovery in this field. So, I mean, those are just some of the things we can talk about when we're finished today. I'm fine with that. Court. Okay. Okay. Very good. Thank you, Judge. Miss Auger. Thank you, Judge. Sidebar conference concluded. Is everybody else exhausted? Is everybody else just exhausted at that? What the hell? Good God. I mean, okay. So we're back from the sidebar. So was Toodles. Get over here, you. Okay, court. All right. The defendant, so back in court. All right. The defendant has filed a motion for pretrial hearing on April 30th. I set that hearing today so that we could discuss the issues that you've raised. Before we get into that, earlier this morning, Deputy Attorney General Aaron Ridlin appeared on the behalf of the Department of Corrections. Okay, right? Because we know where this is coming from. And if you don't, it's Mr. Rozzi's tort notice of whatever. Ask Michael in the chat. The Department of Correction is a non-party, and the defense filed a motion to enter a stipulated protective order. I granted that motion and sent the order to the clerk of court on May 2nd. For reasons that I do not understand, the clerk of court never entered it. What, Jody? No. As an actual order of this court, and the Deputy Attorney General appeared. Oh, shit. Oh, God damn it. Okay, look. There's such precious little joy in this situation, but damn. Here's Judge Gull. This is my interpretation. Judge Gull is throwing the clerk under the bus for making the Assistant Attorney General appear. I think it's also what Baldwin told me last week is that it was also Tobe Lesenby's fault, not hers, that, what's his name, Baston didn't appear. If I might say, there's a pattern. I mean, okay. Anyway, moving on. I granted that motion, sent the order to the clerk, blah, blah, blah. I provided him a copy of the order. I had my staff go ahead and enter that order. It was entered on CCS on May 7th. I provided a copy of counsel at your table, so I don't know what the disconnect was, but I did grant that. Mr. Rozzi, Judge, I spoke to Mr. Ridlin in the hallway. He departed the courthouse because he felt like his business was finished today. So I think we're all on the same page about what we're trying to accomplish. Court, okay, so then I'll get a duplicate copy of that. Are you ready to proceed to your motion, Mr. Rozzi? Judge, I am. May I inquire as to are we dealing with a request regarding the scheduling issues, or are we dealing with a request or rejoinder for a hearing on the state's motion in limine? Court, both. Mr. Rozzi, okay. Well, if I guess it's the defense's view that if we're going to address the state's motion in limine, it's their motion, so they should have the burden of proof to introduce that evidence. Introduce what evidence they need to do. What evidence they need to do, make their arguments, and evidence should be limited. And then we would have to respond to that, the court. So you filed a motion for a pretrial hearing, but you do not wish to have a pretrial hearing? My God, that is not what he said, ma'am. I mean, am I reading this wrong? Wow. That was kind of snotty, y'all. I don't think that's what he said. I don't think that's what he said. Okay. Anyway, so you filed a motion, and I can just imagine God to have the audio tapes. Ugh. So you filed a motion for a pretrial hearing, but you do not wish to have a pretrial hearing. Mr. Rozzi, I filed a motion consenting to the state's request for hearing on a motion in limine. The court, okay. So the motion for a pretrial hearing that you filed on April 30th, you requested a pretrial hearing to discuss scheduling issues associated with the trial, secure the appropriate amount of time for trial for a defendant eligible to present a full comprehensive defense, and to address any other pretrial matters that may be necessary. Mr. Rozzi, very good. I can comment on that. The court, okay, go ahead. So again, she's just, somebody said he was talking about the motion in limine and she knows it. God. Ugh. Okay, go ahead. Mr. Rozzi, Judge, obviously we're looking at a trial calendar, and the court has communicated with parties through an email indicating the trial was going to commence on May 13th here in Fort Wayne, and that this trial was going to end on May 31st in Carroll County. Those dates, in my interpretation of the email, I think you used the phrase, quote, not more or less, end quote. They're not flexible dates, and those were firm dates we were going to be adhered to in this case. And naturally, I understand the court has not been a party to the exchange of the actual witnesses and exhibit lists because of the way the state and the defense has chosen to communicate. We filed notices that those witness lists were exchanged, but we did not share those with the court. So that would not not become public, at least on our side. And so I understand the court may not have a full grasp in terms of context and number of witnesses that will be called and the amount of exhibits that would be introduced. Without all that being said, I think I shared with the court in the motion that, you know, that I haven't counted them up to date, but I would say that each witness list at this point was over 100 witnesses. And that's probably half of those are duplicated. The other half are not. In the normal course of a trial, I would expect that, you know, only a percentage of those would be called. And so I don't expect the court's going to see 200 witnesses starting next week. But it's pretty obvious to me the volume of witnesses and exhibits, at least in the opinion of the defense, would require, you know, substantially more time than the 2.5 weeks that's set aside to present evidence. And with the defense going second, that puts us at disadvantage, obviously, because we don't know how long it's going to take for the state's case. So we've got a problem. Okay, if you're going to limit the time that we have to introduce and put on evidence, are you going to split that time in half? Is there going to be some manner in which court divides up that time, or is there some equity in the process? I just practically don't know that we can do this in that short period of time. And that's even taking into consideration that we're going to be working on Saturdays and maybe into the evening hours a little longer. I don't want to be in a situation where for 2 or 3 or 4 weeks or 2.5 weeks, we're sitting here, we're staring at the clock every minute. And so I'm looking for a practical solution that I think the defense is looking for a practical solution. I haven't had any conversations with Mr. McClellan about how long he thinks it will be to present his case, but I feel like we both have a pretty good idea of the scope of the presentations, and I just don't see that we're going to be able to do it in that time frame. The terms of the law that's applicable, I did lay some of that out for the court. I don't really feel like I need to sit here and make legal arguments. To me, it's more of a housekeeping or a business related matter in terms of how much time the parties will need to present their cases adequately. But to the extent that the law is applicable, it seems to be pretty clear to me that one of the burdens placed on the court is that the court, before issuing any kind of, I'll call them restraining type orders or orders of restraint where you are setting specific timeframes, that the court must be fully aware of the scope of the evidence that's going to be presented and the witnesses that may be called. And that's based in mostly federal law that has trickled down to the state, because that's where you get most of the regulation regarding the length of trials and presentation of evidence in federal courts. But the law is out there. And I'm not sure whether it's just, I think that this case, just because the kind of nature of the communications between the parties, which we all acknowledge are, you know, not the most streamlined. I mean, at least I acknowledge that. And that's just the way it is. And that's fine. But we haven't had a lot of dialogue about what's ahead. We haven't had a lot of pretrial hearings in the terms of motions in limine and things like that. And so I understand the court doesn't have a good grasp. At least I feel like the court doesn't have a good grasp on the scope of the evidence. And so I think it's a little premature to set dates without the court having a better understanding of what would be offered up. I think in September or October, we had a phone conversation. And I believe during that phone conversation, we were discussing the January 2024 trial date. And at that time, I believe the court inquired to the defense as to what we were thinking in terms of times as far as the trial is concerned. And I believe I'm the one who actually suggested it probably would take approximately two weeks, more or less, to present our case. I still think that's basically true. The words more or less matter a lot in cases like this. And when you've got jurors could be sequestered for long periods of time, you're moving staffs from one jurisdiction to another, I understand. There's a lot of logistical challenges that are on the court, but I still feel like our position hasn't changed. It's probably going to take us a couple of weeks to present our case. And obviously with the May 13th through May 31st trial setting, with part of that being consumed by jury or Vidire, it just doesn't provide us with the amount of adequate time to present our case. And I'm opining that the state probably is going to feel the same way, but Mr. McClellan and his staff can speak for themselves. So we're just looking for some practical solutions to those problems. And that was the purpose of that order. And so that's the defense's position. Court, Mr. McClellan, Judge, I have done what we can do to streamline our witnesses and exhibits that we plan to introduce. You know, I'm not really sure how to respond. The state doesn't have any objection to the 2 weeks. Of course you don't, Nick. The state hopes to have its evidence done and concluded by the 25th. That still leaves a whole nother week for the defense to present any evidence and any rebuttal evidence. That's our biggest guess at what we've got. Again, we've tried to streamline it. We've got it down to 40 or 45 witnesses, and a handful of those, about half dozen to a dozen, will be chain of custody type witnesses. We're trying to work through some of those issues with the defense in terms of stipulations and whatnot, but that's where the stipulations. That's where the state's at. The state's satisfied with the amount of time the court has set aside. That's the only comments I have, Judge. Court. So what's your request, Mr. Rozzi? You're indicating I set this matter at your request for speedy trial. You made your request on March 6th. On March 7th, I set it for trial May 13th and May 31st. And this is the first time I'm hearing of it. The specific dates are not adequate. Is April 30th in your filing? Okay. I'm going to stop there for 1 second. March 7th, she set the trial for the 13th. By April 30th, there was a filing about getting clear on the timing. Okay. That's what I'm getting from all this right here. Okay. And so Mr. Rozzi responds, yeah, that's the defense's request, is that the court not bookend the back end of this trial to a certain date, that day being May 31st, that the court understand the presentation of evidence is just part of what professionals do in a case like this, and that this occurs in a natural situation, a natural setting, and it ends when it ends. And to the extent that there is a need to, regulate these timeframes in a more strict sense, that we would sit down, maybe with the court even, to consider requesting some or issuing an order that might further define the witnesses. Now we're getting closer to trial setting, and the discovery is getting closer to being completed, and then make a decision after, Mr. McClellan, for the first time today, for example, just suggested they thought they had about 40 witnesses. Well, that's, 30 to 40% of the witness list we've received. So that's an indication of how fluid this case is. And so I would ask the court to either consider some further discussions with the parties and further define these witness lists at the end of the week. But at the end of the day, it seems like we're kind of at the mercy in terms of how long it's going to take them, state, to present evidence. And there's also rebuttal evidence that has to be taken into consideration as well. I think those things are not overly predictable, especially in a case like this. We've got logistics in terms of getting experts to and from, and those will cause, I'm guessing, some further delays. And so what I'm asking the court to do is not set an end date for this trial and understand it's going to take more time. I would ask the defense be given 15 days of actual trial time to present its case, 15 working days that would be the request by defense. And some of that has been based on our predictions back in September and October of 2023. And having seen the witness list being modified over the last couple of weeks, because frankly, discovery continues to come in, and that's just the nature of this case. We take depots tomorrow, and it's true. Mr. McClellan mentioned that there is some stipulation that we are working on. Ms. Diener and I have been communicating in that regard, and I'll try to streamline some things that were more efficient. But at the end of the day, I think that we're going to probably need 15 days of courtroom time to put on our case. And that's what I'm asking the court to consider and grant. The court, well, you understand. Well, maybe you don't understand. Jury Rule 4 requires I issue summonses to the jury and the dates of the trial. Wait, is that true? Anybody? Is that true? I remember that when this happened, the trial got rescheduled, which is that, right? Well, I know. I mean, so what I've heard so far is that this is not how it works. So again, the reason I chose this particular reading is because it shows the symbiosis, if you will, between Judge Gull and Nick McClellan. Nick's saying, I can do it. I mean, I'm probably going to be done by the 25th. That leaves them a week. That's not how this works, sir. That is not how this works. And so let's just take this as an example of what is not right. I mean, even Judge Bev, let's think about Judge Bev for a minute. Even at the end of the day, she had to concede, no matter how much she detested the defense team, that the rights of the defendant to put on a case are paramount. Even she had to conclude that. Why? Because it's the goddamn law. Right? This is asinine. All Mr. Rozzi is asking, hey, can we just kick the can down the road a little bit here on the end date? Right? There is no harm in that. The case, the defense's case, as far as scheduling and all that stuff, I understand. And people put their best estimate on it. But McClellan is up here saying, Judge, I only need 2 weeks. So why don't, and this is me just spitballing. My interpretation from this is that they came into this knowing that they were going to force the defense into a hole. Now, wait a minute. Let me stop here and say, I think that this case should have been continued. I mean, they should have either gotten, I don't know. I think that there's a lot of arguments for the case continuing to be continued for trial prep on the defense's part. But setting all of that aside, setting aside what we may think about what happened and what the state of affairs is right now, the bottom line is that the state acting under, Mr. McClellan is the state. He's talking to Judge Gull, who is supposed to be just a gatekeeper, just an information taker and a, evidence gatekeeper, right? Sure, she's got to schedule trials. Sure, she's got logistics and all of her staff who stayed out near the jury, by the way, to get back and forth. Sure. All of that stuff is important, but guess what's the most important? Guess who the most important person in the room is at this moment? And people hate it, but the truth is that it's the defendant. No matter how heinous the crime, the most important person in a criminal trial to make sure that they are wrapped in bubble wrap with the Constitution of the United States of America, it's the defense, though. And so to me, even this first exchange between McClellan and Gull sound a lot like, wink, I only need this much time. We're good. I'll be done by the 25th. Trust me, bro. And Mr. Rozzi, and she's kind of like, yeah, I mean, like, right? And then Mr. Rozzi's like, listen, that's not how this shit rolls. And she's like, right? And McClellan's like, yeah. Like, and it just gets worse. I don't know if anybody thought that my impressions were on point or not. But, okay. So this is where it gets a little heated. Court, well, you understand, maybe you don't. Jury Rule 4 requires that I issue summonses to the jury with the dates of a trial. Hang on. One moment, please. Please stand by. Sorry. You all can pick those up, completed questionnaires, blah, blah, blah. So she's going on here about Jury Rule 4. I don't know if anybody has that, but I issue summons to jurors with the dates, particularly in this matter. Now, see, is this truly an Indiana thing? Because I've gotten a jury summons and it's open-ended. It's open-ended. I mean, correct, Jamie. Yeah. And I'm like, who cares? Right? Yeah, you did. You know why? Because look, she's a French fry judge. She's a hanging judge. In my opinion. I've not seen that. Does anybody know? Because the last time I got a jury, it was actually kind of cool. So last time I got a jury summons, it was for, was it for federal court? So you know where the law and order people go? I got to go there. It felt really fancy. But because I have multiple sclerosis and it's unpredictable, I was disqualified because because something could happen in the course of a trial where I would be eaten because of my health. And so there was no end date. It wasn't, hey, we're only going to need you for 3 days. And my husband sat on an attempted murder. God love him. Oh, he's so cute. He sat on an attempted murder thing 100 years ago. Same thing. So I don't know if it's Indiana or, so somebody says that they have to include trial dates, both of front and back. Oh God, thank you. Yeah, hit that. Yes, I never say that. I never say hit the like and subscribe and all that bullshit because I'm just terrible at this. And I'm gonna, yeah. I don't know, man. This is interesting. Unfortunately, there's no oversight or organization that instrument. Yeah, I mean, it's rough because you're right. I mean, there are actually, oh, you have. Okay, so interesting. And you're from Indiana. An end date. Okay. Oh, you have never. Okay. All right. Right? Okay. Yes. Okay. Thank you, Kristen. Thank you. We got confirmation incoming. We got confirmation. Thank you, Kristen. So it just felt odd to me. Felt real odd. Felt real odd that okay, so let's compare Mr. Ives and what he said, making sure that all the evidence gets out there, and think what you want about Ives. But I can't imagine Robert Ives standing up there and doing a Nick McClellan saying, yeah, look, man, hey, you're right. Bookend that shit. I'll be done by wink the 25th. Are you kidding me? I don't think that is what he would have said. I think he would have said, okay, we can be flexible and, yeah, we're fine with that. Or maybe somebody in the court would have said, that's actually not the truth, Judge. And maybe they do. The laws were changed in the past 3 years. Okay. I don't know. I'm gonna have to look into that, but, there she is. I mean, this is true. Yeah, I mean, I'm not trying to throw any bouquets for him, but I'm saying comparatively speaking, and you make a good point. Ives was saving his own life and got cowardly. I mean, maybe that is so, right? But and I guess his integrity doesn't. If that's the truth, and he chickened out, then his integrity doesn't matter for much. because, but I do think that if we look at it in a vacuum of the leading up to that, he sounded, at least on the surface, is a more reasonable, or at least, you know, more ethical, question mark. It'd be hard to be less ethical than Nick McClellan, in my opinion. Okay. I actually do have I'm not sure who Ivy Bush. Okay. I just read your name. I showed her the updated laws regarding juries. Okay. Thank you, Ivy Push H. And I actually do have an email out to her because I want to try to touch base with her, maybe do a live with her before I get out of, before I leave this place next week. So anyway, let's see. All right, I'm going to get through this as much as we can because I know T has a live coming up. Okay, so she yaps on about, she's very regimented, right? Jury rule number 4 requires I issue summons to jurors with the dates. Oh God, I need somebody to look that up. And God damn it, we're going to do a part 2 electric boogaloo. If you know, you know. Sorry, that banner is starting to drive me crazy. Yeah, I don't know about that. Let me see, jury. It's top secret. I'm leaving on a midnight train to JFK. Now I have school I have to go to across ye old Atlantic Ocean. So yeah, I'll be out of America. Maybe, I don't know. Will I get back in? I don't know. Stay tuned. But I got some studying to do. Not fancy, just necessary. And I have family that lives there, so it's fancy. Truly, it's really not. Excuse me. Trial rule 4. Jury trial rule 4, Indiana. Let's see here. Boop, boop, boop. Strict deadlines, speedy trial, time frame of trial. Okay, it doesn't say. Let's see. Process appearance. Let's see where it says jury. One moment. Jury rules. Scope, pool, notice. Okay, let's see what the notice says. And so, let's see. So let's swap this out. And again, this is the kind of exciting shit I do all day long when I'm actually doing reporting work, which I haven't been doing. I've just been doing homework mostly. But like, you're getting the full cha-cha, folks. Let me remove this for a moment. See if this works. It did. All right. So this is jury rule. Jesus Christ. Jury pool and summons for jury service. So this was effective. See, now this says it was effective in 2010. Anyway, I'm going to scan this just to see. Not later than 7 days. And this is what Gull cites too, right? Is the, and there could be other rules in here. This is the first one I came across. No later than 7 days after the date of the drawing of names from the jury pool, the jury administrator shall mail to each person whose name is drawn a juror qualification form and notice of the period during which any service may be performed. Okay, so that's a period of time, a period during. Let's see if they put parameters on that. The judges of the courts of record in the county shall select by local rule. So God knows what that is. One of the following procedures: single tier notice summons. A jury may send a summons at the same time, a jury qualification form, blah, 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 2-tier notice summons. Okay, 1 week before. The summons shall include the following information: directions to the court, parking, public transportation, compensation, court policies regarding the use of electronic communication devices, cell phones, PDAs, smartphones, etc., attire, meals, and how to obtain auxiliary aids and services required by the Americans with Disabilities Act. The judge may direct the jury administrator to include a questionnaire to be completed by each prospective juror. The judge may order a prospective juror to appear upon less notice when, in the course of jury selection, it becomes apparent the additional prospective jurors are required in order to complete jury selection. The judge may authorize a jury administrator to use technological programs for receiving responses. Okay, so it says period of, all it says here, notice of period during which any selection of service, but that's selection, right? That's jury selection. I know, and I was like, what? Of course there's no PDA in court. So I don't know if that's, I mean, I'm looking at on the other screen here, jury rule. No, it doesn't actually say with the dates. Did nobody know that? I mean, right? Am I reading this correctly? I'm reading this correctly, right? It doesn't say you must put in the dates. Notice of the period during which any service may be performed. Okay, thank you. Love my chat. Love the chat. Okay. Jury service. Person who appears for service. Teacher serves only at the conclusion of the first trial. The juror is sworn in regardless of the length of trial, the manner of trial. Okay, this doesn't say anything. Call for jury service are eligible to serve any court in that county on the day summoned. A person who has one served as a juror may not be selected. This is just So that doesn't have dates. May be selected for any other jury panel. That's and this is also I appreciate that, but that's not what she cited to. So I guess I'm staying with what she said. So okay. In Indiana, we get a notice for a week of jury service and then have to call in. Yes. Okay. So now this is something I have heard of. Thank you again. And thank you, Ivy Push, as well. My friend Kathy was actually in a murder trial in Minnesota and she was sequestered. I should actually interview her. It was very interesting, her perspective and the way that jury comported itself. Holy hell. I could get Kathy on here. She'd love to talk a blue streak about it. If anybody's interested, whatever. But that was the same thing. So they would have a procedure where they would call in the night before. And again, I'm telling you, they were sequestered. And at that point, I don't think that there was a conclusion date. I think that they just had to make arrangements. Because if I remember right, she was telling me, and again, I know these are different jurisdictions, but I mean, just Rule 4 doesn't even say that. Yeah, I don't know. I mean, I don't know. Damn it, somebody's at my door. Are you interested? Okay. Hang on a second. I got to answer my fucking door. Baby. All right. God only knows what that is. Okay. Right? I've tried to cover it up and it makes me crazy, my doorbell. Okay. So I'm not going to be able to finish any of this today because T's going to do her thing and I'm not running up next to T. I know. Listen. It's like, ugh, I know. Listen, I know the doorbell is terrible. It's not down to me. It's down to the management company. So I'm not going to get to finish what I started. And I know, oh my God, yes, I do. I was like, look out behind you. Belly May says, remember when someone was knocking on Andrea's hotel door when she was live streaming? Yeah, that was a little weird. So what have I brought to the table today? Practically nothing. So have you pushed this? How many other states allow deliberations? I don't have any idea. Right. I mean, and so this is the other thing about my friend Kathy, who is sat on this jury, is that even in sequestration, during that murder trial, and they, oh God, they had to have roommates. I'm like, what did you say? But anyway, they couldn't even, there was no TVs. Everything was removed from their rooms. They couldn't have they certainly couldn't visit family and have barbecues with the bailiffs on the weekend. What is happening? Woo! What is that? Hang on. Something went haywire with my screen. Can you see any of this stuff? Let me see. Hang on. What happened? Can anybody still hear me? I'm not sure what happened to my screen. What is happening? Huh. I do not know what happened. And I do not know if anybody can hear me, but having some technical difficulties, and I don't know if it's StreamYard. Let me see. Am I back? That was really weird. Oh, all right. I don't know what happened. It just went down. But anyway, okay. Weird. Chat still pops up. Okay, so that was really weird. I had to close out and just reopen. So sorry about that. But I just came back on to say I'm going to let you go to see whoever. I think T is doing some stuff today. I've got stuff to do today. And I didn't get through this whole motion, but you know, I don't know. Let me know in comments, or, you know, my email is andy@andycopsa.com. I'm not great about it. But I try. I mean, if there's things that you all want to discuss or talk about, I don't know. I'm down. But yeah, I am going to be, what's the date today? Yikes. Okay, so I'm leaving in 6 days. So, anywho. What? Oh no. Okay, so that was a mess, but look, you get what you get, words and all. So I do think that that is a really valuable transcript to read. And I believe I linked it in the notes below this, and it's on All Eyes, email, or I'm sorry, website, that leads to all the transcripts and all the exhibits and all that stuff. So yeah, it's a good read, and it shows really kind of, in my opinion, where just abject fuckery. What? Oh God, what was that from? Apps not appetizers. Who knows? All right. So you know what, you guys, this is gonna have to be it for the day, because it's 1, and I think people who are listening want to go listen to T or whoever. As always, thank you for flying the duct tape and rubber banded together airlines of Andy Cops Airlines. And hashtag never forget that I think that all of you guys are just